applies the Constitution. That is not what you're inviting me to. An act applies or interprets the law. That is what you're inviting me to. This law, section 19, section 94, subsection 1. And at this juncture, Your Honor, you might want to seek the aid of the interpretation.
Council should just stick to what came out and the law so that we are not able
He addressed you on the applicability of Article 10, Your Honor, and I have simply dealing with the question of Article 10. I invite you to apply the tool of the Golden Rule. In 1930, when this section was being enacted, what was most relevant was the mischief rule that Parliament, as at that time, wanted to address. And this case is the Parliament of the United Kingdom. Granted that this country was a protectorate as at then, and Her Majesty government wanted to guard, control, and subjugate the people of Kenya.
Your Honor, seriously.
Yeah, that's what.
I'll abandon that, but I know the court has noted. Now that we have the new constitution, so that you may not resort into the absurdity that the DPP is inviting you to, you must apply the tool that enhances the enjoyment of a right other than to limit it. And that you're being invited by Article 19, 20, and 21. To argue that Section 8 of the Magistrate Court limits you, again, would be to miss the point. There is no possibility that the Constitution can give you, under Article 10, which provides, again about these values, and I want to just mention the value of human rights, that when seated there, Your Honor, you are bound by the values of human rights. And where do you get these values from? The Bill of Rights. So are you then supposed to apply the Bill of Rights exclusively? If you're then being invited that the only jurisdiction is under Section 8, subsection 2, then how are those rights contemplated? They are capable of being denied, violated, threatened, or infringed. By the deliberate use of the word threat in the section, threat, violation, denial, or infringement invites you to holistically analyze the entire concept of human rights. It does therefore not limit you under Section 8, subsection 2. Otherwise, how can the Constitution give you and then a legislation take it away from you? Then when interpreting that Section 8, again, you must interpret it in a manner that advances the enjoyment of that right, other than limiting it. Again, that is again on the doctrine of the law, that you expound the law in a manner that facilitates the achievement of that objective. I will again address you on Article 50, clause 2, paragraph B. And this, I'll leave it at this and then invite Mr. Raku, because this article, Your Honor, tells you that when a subject such as honorable member is brought before you, must be informed of the charges with sufficient details to answer. So the DPP does not just have the liberty of crafting anything and anything goes. That as long as you are here, the only obligation is to answer.
Your Honor, this argument was made by counsel when they were making their argument. What we understand, let me finish, sir. Let us just have courtesy. What we understand as response, let's sit and finish it.
So just sit down.
Yeah.
You look that they don't have a place to sit.
No, we are pleading that in response, so that we don't regurgitate, we just issues that have arisen.
Okay, I'll abandon that argument. I'll take that protection. So that, Your Honor, I'll then invite my and try to proceed.
So, Mr. Njiru, before you invite,
yes, sir.
Don't you think if you urge me, as you have done, in view of that section 7 of the 6th section,
yes,
do you think that will be cited for judicial overreach?
No.
It will be a classic case of judicial overreach.
There is no judicial overreach because if I was to read, and again for the benefit of my learned friend who seldom refers to it.
Sorry, this second time I'm not taking it. I am a master's holder in constitutional law. It's not. I am an advanced master's holder in constitutional law. It's not. So you should not throw those shades. I am extremely intelligent and brilliant and learned. You should not throw the shades.
It's one thing to hold a master's and
sorry, yeah, I'm not on trial, Your Honor. I'm asking you to just respect me because I am not. No. Yes, this is the second time counsel is attacking me and I seldom, but I am asking him to respect me because he's my friend.
Okay.
That's not the matter.
Yes, Your Honor.
Mr. Witt has demonstrated his credentials.
Yes.
Let's not challenge it.
And we are not surprised by those credentials, but surprised by the inability to apply the same.
I am not the kind of person to be intimidated by people like Mr. Ndegwah. So this court should just direct him that he respects the court if he doesn't want to respect me. And if he doesn't want me to lose my respect for him today. Because I take my education seriously, having listened from Islam, that I can't allow someone to just make shades. So please, just respect me.
Let's not dissent that. I was actually about to praise the council for their appropriateness and their propriety, but now I think we almost dissented.
Yeah.
Let's just maintain our cool and decorum.
Well,
You already wound up. I was just expressing that perspective.
Yes, Your Honor. There is no judicial overreach because the philosophy behind the enactment of Section 7 was in the mind of the drafters of the Constitution that there exist laws and there was need and the necessity to save those laws so that they may not all be considered to be inconsistent with the Constitution by virtue of Article 2 of the Constitution. And that is why, Your Honor, Section 7 says all laws in force immediately before the effective date continues in force and shall be construed with the alteration, adaptation, qualification, and exceptions necessary to bring it into conformity with this Constitution. So this is an invitation to any judicial officer who seeks to adjudicate over a dispute. Additionally, Your Honor, this is also in respect to any other state organ that is invited to apply laws. For example, the procurement laws that were enforced before then, or perhaps the marine laws that were enforced before then, or any other law. So there will be no judicial overreach, Your Honor, if you are then to apply, because that is a constitutional invitation that you cannot avoid. Most of that.
Thank you, Council. You're the last one, Mr. President.
I think the chairman has two sentences. Just 2 minutes.
Your Honor, I don't know whether this would be an interruption of the proceedings.
Mr. Witty has a habit of always rising when I rise. If I stand, I can submit when he's standing. I don't have a problem. But let me make my submission.
Your Honor, I was just going to make a small request. I am not your enemy, sir. I was going to make a request that before they are done, we let them finish. I just want to mention an authority. I'm not arguing. Just bring it to your attention if you allow me to read a paragraph so that as he responds, they also tackle.
No, we are beyond that.
I am allowed to make an application to reopen.
He has already closed his case.
Yes.
I'll address that. Let's just finish with that.
Okay, that's fine.
They are responding to what you raised.
He cannot be allowed to be sitting.
I think the court has directed. The court has directed.
Yes.
Yeah, very briefly, very briefly. There is a suggestion that we are inviting you to a mini trial prior to appeal. In many words, that's how we call it. We are not asking you to evaluate any evidence. We are only asking you to look at the content of the charge sheet in terms of the wording, and look at the relevant section of the law that is said to be based, and make a judicial determination in accordance with section 18, subsection 5. Also, section 194 of this case. That is all what we are asking for. When prosecution brings a case before you, a charge sheet that is before you and a suspect before you, it is in exercise of the ODPP's power under Article 57. We talked about this. And as I had said earlier, this power must not be abused. Indeed, and Mr. Witty knows this very well, that what sub-article 11 says is that that power of the DPP, in exercising the powers conferred under this article, the DPP shall have regard to the public interest, the interest of the administration of justice, and the need to prevent and avoid abuse of the legal process. A charge sheet is brought before you that is clearly an abuse of the process. Your Honor, that is a charge sheet that you should reject, and the court gives you, the law gives you that power. Lastly, last today, Mr. Kibe Mungai told us in another court setup, that there's a reason why that the new constitution, the bar on this side, the defense, the prosecution, and the bench was made to be advocates. We no longer have police officers on that side, advocates, and then there used to be district magistrates on that side. Those days. Now we have advocates. So that when materials are brought before the courts, the level at which we interrogate them is not the basic level. We should present before the court, and then before the court, and the court applies its mind, its legal mind, to assess a situation so that we prevent and avoid abuse of process. How do I say this? There was a suggestion by the Fed that when a charge sheet is brought before you, your role is to tell the accused person plead guilty or not guilty, and then evidence will come to prove or fail to prove. That is not what the Constitution envisaged. It envisaged a situation whereby all the parties would have some basic meeting of mind as advocates, that indeed this charge sheet, we may fail in evidence, and this one is also in the decision to charge guidelines. We may not attain 100%, but it is unreasonable. The charge sheet is in the direction of something that we can prove. So you're being told, yes, there's nothing threatening, there's nothing insulting, there's nothing offensive, but nonetheless, let her take plea we will move along and see what we will do along the way.
I hope we didn't say that. I hope the record will help us.
Let's move. We'll learn where we find ourselves. We'll decline that invitation and find that this is not a proper charge that the person before you should take. I invite you, Chairman.
Thank you. Well, I will be brief. And I will start by quoting Justice Odunga in Republic versus Director of Public Prosecutions and another, Spate Chamanlal Kamani, whereby